Morning, Your Honor. This is Attorney Al Needham for Defendant Del Casal.
Morning, Your Honor. Kurt Harris on behalf of the plaintiffs.
Okay. Counsel, I have a motion for ruling on issues of law. Why am I hearing a motion a week before trial?
Your Honor, prior to the motion being filed, that we had a pretrial conference, and the parties had filed pretrial memorandums. And in the memorandums, we set forth, of course, the issues of law. And so my thoughts were that the motion would probably be the best way to get those answered. I could have filed and put in front of the court either. I wasn't sure how the court would want to handle those issues of law, how they would actually answer the questions, either by way of a motion hearing, chambers, or briefs. So hopefully that answers the question, Your Honor. I felt this would be the best way that everyone could. I felt this would be the best way for everyone to be heard and for the court to answer the questions. But if the court has a different preference or doesn't want motions filed like this, I guess the parties could just submit briefs.
Well, that's the problem, counsel, is I have a motion without a legal basis for hearing it. I've got a motion of issues of law, which basically is a motion for summary judgment being heard a week before trial.
Yeah, I did cite the pretrial memorandum rule 2.67. You're right, and I thought this would be in furtherance of that rule. But if the court doesn't want to hear motions, like you said, before trial, then this, because there are other additional issues, I thought this would be the best way to do it. But in the future, then if the court doesn't want to have a motion filed like this, they won't be filed.
Yeah, no, what I'm saying is if this would have been filed 60 days before trial, I would have heard it, or if it would have been filed even 30 or 35, 40 days with an OST. But I've got basically a motion asking me, really, motions for summary judgment a week before trial.
Yeah, the reason why I got some jury instructions proposed by the plaintiff, and some of these issues, for example, when we had the pretrial conference, there was obviously the exhibits were provided by Mr. Harris, the plaintiff, and in the exhibits it's pretty clear, and those are on record too. You could see a list of them with the pretrial memorandum. There's no documentation of any damages in this case. No documentation of damages. So when we turn to the jury instructions, we're looking at several claims like breach of contract and theft and all this, which have a damage component. So it seems logical to, if there's no documentation of damages, why are we spending time dealing with jury instructions and all that? And so it went into the preparation of jury. That was one of the main reasons, Your Honor. When I saw no documentation of damages, I felt it would, let's get this in front of the court and see what the court thinks.
Okay. So basically you're making a Pizarro-Ortega thing saying I don't have a computation of damages, therefore Mr. Harris can't present it to the jury.
Yeah,
so you do that at the time of trial.
Okay. Well, yeah, I thought I would try to simplify the issues. I guess the spirit of 2.67, trying to simplify matters and get, when there's 8 or 9 cause of action over a defamation claim, I thought this would be a good way to try to simplify some of these issues, and of course the preparation of jury instructions and all that, in a more orderly manner versus spontaneous, when we're all in the midst of preparing jury instructions and all that.
Understood.
So that is true, Your Honor. There's been no computation of damages, and there's been no documentation of damages. I mean, that to me is significant, and it could be ruled on right now. So the parties, including Mr. Harris, I think he benefits from this, because if we can streamline these claims, it goes to the plaintiff's benefit as well.
Harris, comments?
Thank you, Your Honor. No. This is a summary judgment motion, essentially, for all intents and purposes, and I do not read EDCR 2.67 at all the way that Mr. Needham reads it. So.
Well, I can agree with Mr. Needham that if this would have been filed, like I said, even on OST a month ago, it would have been one that I would have entertained. But the fact that I'm getting a motion for summary judgment really is what it is, a week before trial, it's improper. It's not timely. Motion for rulings on issues of law is denied. It's an untimely motion. We'll see you guys in trial.
Thank you.